either an infraction of Title 28, which is all that stuff, or Title 13, which is the criminal code here in the state of Arizona. So those are the things that are going to, if you violate those laws, if you have something wrong with your vehicle along those lines, they're going to initiate a traffic stop on you. And then, of course, if you are the victim of a crime, you witness something or something along those lines, those are also concerns that you need to have as a cannabis patient when you're making contact with law enforcement contact. It still could come up, and you still have to be within your rights. You still have to have your card on you and all that. We'll do exceptions here in a minute as well, but law enforcement does have to have a reason to pull you over. There's pretext stops, and we're not going to get into that. But they do have to have a reason to pull you over. They have to have reasonable suspicion of an infraction of the law to initiate a traffic stop on you. I put this in there so that the public can understand a little bit what law enforcement faces and why they act the way they do, why they behave the way they do. And a lot of questions come from that. Like, why do the officers get out of the car? Well, there's reasons. And I just briefly touch over that because there's really no other profession in the world that gets killed simply for being that profession. So the reason why officers do some of the things they do is just kind of highlighted here. And that is the dangers they face. The fact that there's so many officers murdered, not killed in car accidents and all that, but criminals actively seek out and attempt to kill law enforcement. So I just add this little blurb in there so that the public can kind of see what law enforcement faces on a daily basis and why they have to be careful and why they do some of the things they do. So this is just some of the numbers of the ones that have been murdered last year. So I want to go over some misconceptions about law enforcement. Some of the myths just up here, just a few brief ones. They had no reason to stop you. Okay, well, again, there has to be an infraction of either Title 28 or Title 13. You throw litter out of the window, that's a reason to pull you over. You have a headlight out, that's a reason to pull you over. You're speeding, things along those lines. Law enforcement does have to have a reason to make contact with you. In the traffic section, I hear this a lot. There's actually a case right now out of the city of Phoenix involving a city of Phoenix councilman talking about jurisdiction. Well, a huge misconception in the state of Arizona is that all law enforcement throughout the state of Arizona has jurisdiction everywhere. Canal County, Maricopa County deputies, Canal County deputies, any deputy, any police officer, any college law enforcement, they are state certified police officers. They can and do have the authority to pull anybody over for a violation of state law. So if it's a city law, that's different, but they do have it there. Again, highway patrol cannot stop you on city streets. Incorrect. They're the state police agency. You do not have to stop for an unmarked vehicle. That's a huge one, and I actually just covered this with another criminal defense attorney of mine. You do have to stop for an unmarked vehicle. If you believe it is, I'll just touch on this real quick. If you believe that it is not an actual law enforcement officer, because there are many cases of what's called wannabes that are pulling women over. Into it is if you feel unsafe, if you feel threatened, you don't think it's a police officer, pick up the phone, call 911, know where you are, attempt to know where you are, and just say, hey, can you send me a marked officer? Can you send me a marked unit so that I know that this is an actual traffic stop? The problem with that lies, again, just like I said, if a city of Mesa cop pulls you, but they can't dispatch a unit to you. Police cannot speak to you without reading your rights. Two, they can do consensual contacts. They can walk up to you and say, hey, how are you? How's your day? And then can stem a conversation from there. And then in regards to the Miranda warnings, you've heard it on TV. You have the right to remain silent and all that. Law enforcement does not have to always read that to you before they begin questioning. It's very specific. If you're in custody, then Miranda warning applies. However, on a traffic stop, that's not a crime. They're just asking you questions about the traffic stop, and whatever happens from there happens. Okay. A lot of citizens often say, well, they knew who I was when they walked up to the car. Why were they so rude to me? Well, that's not true. So law enforcement officers get very, very limited information when they run a license plate. They get the owner of the vehicle and the type of car in that sense. They're not getting who's driving the car. They're not getting, the intentions of the driver and all that stuff. Or there needs to be a level of respect, obviously, from law enforcement to the citizens and from the citizens to law enforcement. But these are the things that they don't know. And particularly, they have absolutely no idea who is an Arizona medical marijuana patient before they walk up to that car. That information is not revealed. That is HIPAA protected. And I just learned something about that. I'll incorporate that in a moment. So before you get into your, like I said, 70% of citizens are going to have law enforcement contact based on a traffic violation. That's where the most of it occurs. So some of the things that I want to kind of go over is do things to not get pulled over by law enforcement. It's working, your blinkers, your license plate lights, check those license plate lights because hardly anybody does. And I used to make a lot of traffic stops on those. Just very simple things. If you are being pulled over, don't slam on your brakes. And most of my stuff is geared towards the highway because I spent a lot of time on the highways. When you're being pulled over, again, you slow down, use your blinker, and all that type of stuff. You are a medical marijuana patient. Obviously, your is going to immediately raise suspicions to law enforcement. Now, because Arizona is a medical marijuana state, those suspicions are they're going away a little bit. More and more officers are understanding. The officer approaches the vehicle. My biggest suggestions, and my information comes from, like I said, I haven't been in the game for 2 years, but I contacted a lot of my friends that are still working the streets, that work in this area, and they all agree the same thing. It's attitude that goes a long way. It's respect, politeness. Now, again, it needs talk, and will go a long way with the police officer. So that's just my suggestion, is to be polite, be respectful, and don't argue. Arguing on the side of the road never wins with anybody. It just doesn't, unless you're a lawyer. The last one, though, I want everybody to make sure that they see that is do not answer questions that we're not asking. Be courteous and polite, but not give more information than necessary. Answer the questions, be polite, but there's really no reason to go into anything more than that, than what the officer is pulling you over for. And there's a respectful way to do that. There's a simple way of saying, officer, I'm not interested in having that conversation. And just be polite. There's no reason to scream and yell or anything like that. So you're pulled over to regular traffic stop. What is required of a citizen, any citizen on a traffic stop? They're required to give their valid driver's license. They're required to have their valid registration, and they're required to have their valid proof of insurance. Everybody's gone to the digital day now where you can have your insurance card and your information on your phone, and it is valid. If you show that on the phone, you can show the officer your phone. Now, that does not give the officer the ability to go through the phone. They can't start swiping through your pictures. They can't do anything like that. But at the same time, if that officer's holding your phone, you've given them permission, the next thing you know, your buddy sends you a message, and it's got 200 pounds of marijuana and everything else in it. Now that officer may have probable cause to go through your phone. So it's one of those things. Just kind of be aware of what information it is that you're giving. So we don't want to give law enforcement more ammunition than they need, because they're good at their jobs. So the officer walks up to your car. You've given your information, and they smell cannabis. They smell marijuana. Now you have to understand, and Ms. Martinez can hopefully clarify this as well, the law sees cannabis and marijuana as two different things. Cannabis is the extracts, the concentrates, the waxes, the shatters, all that stuff. Marijuana is the green leafy substance that we all know is flower. So walk up to the car, they smell marijuana. That immediately does give them probable cause of a crime that may potentially be happening. Now, with that being said, though, as a medical marijuana patient, we have the responsibility to be within the confines of the law. We have the responsibility to show the officer that, hey, I'm a medical patient, I'm not breaking the law, and that's when you present your matter. Officers are allowed to ask people to step out of the vehicle. Officers, United States Supreme Court case law that goes over that. So if an officer asks you to step out of the vehicle, they're well within the law. And again, until the patient has presented that documentation saying they are an AMMA patient, the officer is still going to believe that a crime is occurring, that somebody is in possession of cannabis or marijuana and they're not a patient. And for those who don't know, possession of marijuana in the state of Arizona is still a felony. It's a class 6 felony, which is the lowest one, but the possession of paraphernalia is also a felony. And here in the state of Arizona, your lighter can be considered paraphernalia. Anything can be considered paraphernalia. So just something to be a little mindful of. So some of my things that I just want to convey also is that, again, you need to present your medical marijuana card, and that automatically lowers the suspicions of law enforcement a little bit. Now, I have had several conversations with prosecutors, with criminal defense attorneys, and with police officers on this next statement. And I agree with the fact, and I put it in here, is that if you're pulled over and the officer requests your card, show him what you have. Ms. Martinez may disagree with me on this, I don't know. But I agree in being open and honest about it. It's like, listen, yeah, I'm a patient. Here's my card, here's my marijuana. Now that will also help lower suspicions. Okay, that will also show the officer that, hey, this person is within compliance. Now, this presentation is for the true patient. It's not for the people that are patients in covering, concealing other crimes, which does occur. So I also had another conversation with several officers who were talking about packaging. They said, oh yeah, it needs to be in the original package. The marijuana needs to be in its original package. This person was not familiar with the fact that there is no law that says it needs to be in its packaging. If you go to your friend's house and you do patient swap and you got a little baggie on you of marijuana, that's legal. Now, there is what is being misconstrued. There is an Arizona Department of Health Services administrative rule that says dispensaries. Do we have any dispensary agents in here, by any chance? Okay, so there is an Arizona Department of Health Services administrative rule that says that cannabis must be packaged in a certain way. You know, when you get your medicine and it's got the barcode, it's got the date, the harvest date, and all that stuff. That's an administrative rule. That is not a criminal code where that us as patients have to abide by. A police officer cannot charge a citizen for a DHS administrator. So with that being said, though, the thing that I learned from talking to my friends that are doing this, talking to prosecutors, is that it is such a gray area. This department teaches this department teaches this. Sometimes the information is not correct, and sometimes it's just not updated yet, and that falls on the department providing proper training to the officers. Will the officer search my car? Yes, probably. And again, this goes back to the conversation that I had. You present your marijuana and the officer still wants to search your car. Is it a valid legal search? Well,
it depends.
It depends. Exactly. That's exactly what it is. It depends. It's offensive as a patient, as a true patient. Well, why is the officer still searching my car? I gave him all of my stuff and all that. Again, it depends. It depends on what the officer is able to articulate the reason for their search. It depends on other factors. It depends.
Yeah, and one of the things I just wanted to chime in, one of the things you mentioned in terms of a stop and showing your valid medical marijuana card, but also in particular, the smell issue. If your car actually smells like weed, guess what? You're being investigated for a marijuana DUI. And the cop will search your vehicle to determine if within reaching distance, you have a pipe, a vape pen, or other things like that. And if they find a pipe within reaching distance and that pipe is still warm because you probably just smoked it, you're being investigated for a DUI and they will be searching your car. So that's what we kind of mean by, it depends. But I know we're going to talk more about how you never want to ever actually have marijuana in your actual car. It's always in your trunk. Always in your trunk.
Very valid point. And then again, there's a big difference between, hey, you have a broken tail light, you're showing the white light to the rear and you get pulled over. And also next thing you know, you're being asked to do field sobriety tests on the side of the road because they smelled marijuana. Okay, and that, again, it depends on whether or not that is within how well they articulate what it is they're seeing. Can they confiscate my cannabis? No. As long as it's within the 2.5 ounces, as long as you're within compliance as a patient, no, they are not allowed to take your cannabis. At least they shouldn't be. And if they do, call Ms. Martinez. So this is one of the Supreme Court case law, Arizona Supreme Court case law regarding the MMA patient and the odor. So presentation of a valid MMA registration identification card therefore could indicate that marijuana is being lawfully possessed or used. Such information could effectively dispel the probable cause resulting from the officer's detection of marijuana by sight or smell, unless, of course, other facts suggest the use or possession is not pursuant to AMMA. What that's stating is that the compliant patient who has cannabis in their car, presents their card, there's no other factors. You're good. There's no more probable cause. There's no reason for the officer to continue going down the road. Now, a reality is that law enforcement officers are seeing criminals that are getting their card to mask other criminal behavior simply because of the smell. Again, I have friends that are still in the business, and I was told multiple stories of drug dealers they got 10 kilos of cocaine and 10 kilos of meth in the car, but they're impatient so that it masks the smell and masks the odor. So while things are offensive to patients, that why is this officer being mean? Why are they being rude? Why are they searching my car? That's a reality for law enforcement. These are things that they come into. And again, I'm not excusing behavior. I'm not excusing violating anybody's civil rights or anything like that. It's just simply a concern that law enforcement does have. That's the State versus Cisco, the Arizona Supreme Court opinion. And I put that 3 different officers in the same department that I had contact with had 3 different answers regarding searching a vehicle. So again, it's a gray area. There's so much to it that it's still a gray area. Odor of burn cannabis. This is where it's really going to push that officer into a DUI. Now, when you have a DUIs in the state of Arizona are misdemeanors, unless you have your kids in the car. Aggravating circumstances, which is having your children in the vehicle. So what's going to happen when an odor smells burnt cannabis? If an officer smells an odor of burnt cannabis, they will search your car. They do have probable cause to search the car. Would you?
Absolutely,
Yes.
100%, and they do each time.
And
they charge.
Yes.
And they likely will charge with 2 different DUIs.
Absolutely. So the odor of burnt cannabis. Now we all understand that cannabis stays in your body a lot longer. You're impaired a lot longer than alcohol. It comes down a lot faster than alcohol, especially edibles and all that stuff. But it's the odor of burnt cannabis that I really want to drive home is an issue. And I highly recommend, if you're going to smoke before, I don't ever condone driving under the influence. I can't do that. The law enforcement officer won't allow that to happen. Again, regardless of who's in the vehicle, it is probable cause for the officer to search the car based upon the smell of burnt cannabis. And again, it will rise to the level of suspicion of possibly impaired. So we don't want to DUI on top of that. It's my number 1 rule. Stop smoking weed in your car. It's a very simple one. I get it. Sometimes you don't have a place to do it or anything like that, but that is absolutely, positively my number 1 takeaway.
Whether your car is in drive or stopped in a parking lot, you cannot smoke weed in your car, really, unless you're like in your garage in your home. Don't. Just don't. I know it's no fun. But if you do, then you're going to have to pay lawyers thousands of dollars to try to get you out of this case. So
they're the influence, and it's driving under the influence of anything. It could be whatever. And then there's also, oh my goodness, actual physical control. So if you have your car keys in your pocket and you're sitting in the backseat of your car smoking, you are actually physically in control of your vehicle and can't be charged with a DUI because you have the car keys. There's arguments in regards to, well, the car wasn't on or anything like that, but that's all been solved by case law, and you will be arrested for DUI.
That's alcohol too.
Any impairment, you're 100% correct. It could be your Percocet pills if you're prescribed opiates or whatever. So yeah, it doesn't matter. It's impaired to the slightest degree, and if you have that actual physical control of your vehicle, that will be a DUI. I had another one here. I wanted to cover real quick, and I know Mr. Martinez is going to as well, cover the DUI laws. And again, the DUI laws are impaired to the slightest degree. So we all know, and if you want to chime in here on any bit of this, please do. When it comes to alcohol, there's a presumptive level that you've ingested this much alcohol, therefore, no matter what, you're intoxicated. You can be arrested for DUI. Cannabis isn't that way yet. There's technologies that are coming out to see if somebody just recently smoked, but we're not here in Arizona yet regarding that.
that's correct.
But in regards to the impaired to the slightest degree and standard field sobriety tests that officers do, officers have very specific training in regards to drug law, in regards to the use of drugs. And they're called drug recognition experts. They're the ones that, the training is very, very expensive. And they run you through more FSTs and all that stuff. But anyways, one of the things that's going to happen is that this is for families and parents here. You're driving down the road, you've got your medication, you smoked maybe an hour ago. The car smells like cannabis. The officer not used, obviously we're a little bit desensitized to the smell of cannabis. You get pulled over, now you're on the side of the road, you're doing field sobriety tests, and you have your kids in the car. What happens? You get placed under arrest, what happens? Well, here's what happens, DCS gets called. Department of Child Services gets notified that you've been placed under arrest. If it's at a period of time, like say it's 1 a.m, you're coming home from whatever, and you have your kids in the car, and nobody can be reached to come and pick your children up, then DCS gets called, they come out to the scene, and they take possession of your children. Nobody wants that, especially as patients for our medication. DCS will open up an investigation and ruin your life for a certain period of time. Whether it's founded or unfounded, still they have to do their jobs as well. They have to investigate. And simply, it also it can be whether you're on opioids, whether you're on alcohol, it doesn't matter. That same process is going to happen. But I believe Ms. Martinez can probably vouch for the fact that when it comes to medicinal cannabis, there's still a huge stigma. DCS is gonna go a little bit further in regarding that investigation. So, leave. That's all I have. Does anybody have any questions?
I think we're gonna leave the questions to the end.
Okay.
Right? We're gonna have her present.
Okay, so then hold on to that question.
All right, folks, so we're gonna switch to speaking a little bit about family law issues, parenting issues, but in that regard, we're also gonna be speaking as to some of the criminal issues, in particular DUI, marijuana DUIs. And as he mentioned, as respects marijuana DUIs, just starting off with that a little bit, if your child under the age of 15 or a child under the age of 15 is in the car with you when you are investigated for a DUI and you're ultimately charged, you will be charged with a felony DUI. You may also be charged with felony endangerment. And all of those things will absolutely hurt you in a custody battle, especially if your ex completely hates marijuana and will do anything they can to take away your rights because of your marijuana use. So some of you, like I said, have the actual hard copy. I didn't make enough, but for those of you who do need it, please feel free to email me and I'll give you a copy. A little bit more about myself. I have been a medical marijuana patient in Arizona since the program started, and was a medical marijuana patient in California since the late 90s. I am also a mother of 2 children and a grandmother of 1 child. So I understand. I get it. I totally understand all these issues. That being said, I have been told that I'm a little bit conservative in terms of my presentation and my advice. The reason I'm a little bit conservative in terms of the advice that I give is because I am a litigator who's in court probably 10 times a week. I'm always in court. I'm always in criminal court or family court. I'm in front of a host of judges, and I'm seeing how these judges are looking at things. And while it is true, just like law enforcement is becoming more educated and understanding these very unique issues, judges are also understanding a little bit more. However, let me just tell you that if you don't know this, not most judges, a good number of judges are actually past prosecutors. If you actually look at, just take a poll of the judges that are on the Maricopa County Superior Court bench right now, a lot of them are past prosecutors. So you have to understand that as well. I have had judges call clients in family court. I had one judge actually call my client just by being a medical marijuana patient, actually called him disgusting. And that was after she argued with me saying, what are you trying to say, Ms. Martinez? That my order was wrong, and it was an order that actually set my client up before I was hired with drug testing. It was a drug testing order. And the judge said, what are you trying to say, Ms. Martinez? My order was wrong. And I said, Medical Marijuana Act. Right after that, she basically called my client disgusting. And that case is actually still pending because there are a host of issues associated with that case. And I bring that up just as an example of a lot of the things that some of you parents may face if you are not the most safest and the most responsible as respects your medical marijuana use. So again, I am going to be talking about some discrimination provisions that protect you as patients. So at least to be aware that there are is a totally different story. I'm going to show you a slide that, and those of you probably who have it already have seen the slide where there are unanswered questions, the gray areas. It's pretty much all gray in Arizona, almost all gray. These issues have not been litigated. That client that I was speaking of, where the judge called him disgusting, I said, come on, let's get a Court of Appeals case going. And he's like, no, I don't want my name on the Court of Appeals case. No. Although I have a recent criminal client who's willing to take one for the team and go all the way to make case law. Bless his heart. So let's start off with the presentation. Let's start off with the discrimination provisions. Just a little bit about them. I'm not going to go into crazy detail, but this particular discrimination provision is in the actual Arizona Medical Marijuana Act. And it talks about no school or landlord may refuse to enroll or lease to or penalize a person just because of their status as a cardholder. Unless, there's the AMA is all about unless failing to do so will cause a monetary or licensing related benefit under federal law or regulations. I actually have a case right now where a person was kicked out of required testing. And if they did test positive, even if they were a patient, they would be just like that right now with a local school that has a medical program where that client can no longer, do what she wants to do, at least in the state of Arizona, at least through that program. Why? Because they're disenrolled just because she tested positive. So we're thinking about suing the school. We're thinking about some different things to do to help that person. But that's definitely what they're facing. But some of you are a custody battle. For those of you dealing with DCS, this is actually the provision that should protect you. Doesn't necessarily protect you, but it should protect you. And that essentially, unless you as a parent are engaging in unreasonably dangerous behaviors, actually has to find that those unreasonable danger behaviors is established by clear and convincing evidence. Without going into too much detail, clear and convincing evidence is kind of like, if 51% of people think that it's dangerous, then it's dangerous. Kind of basically. Yeah, so absolutely the gray area. And the unreasonable danger standard has not really been litigated. What we're going to go through are two cases in Arizona. They're Court of Appeals cases. One that is very lengthy. It's not legal precedent, but it is something that can help guide a lot of judges in looking at these family law issues and looking at the unreasonable danger issue in particular. So here is the slide that I mentioned is essentially, it has a host of questions that have not been answered in Arizona yet at all, which is essentially all the questions. Probably a lot of you have these questions. You want to know the answer to these questions. Guess what? There are no answers to these questions right now. There are none. It's all gray. So, for example, if a parent is a marijuana patient, does that give the parent the ability to take their medication during parenting time? Well, if you're in front of that one judge and call my client disgusting, no, absolutely not. No, his parenting time was absolutely suspended and is still suspended because of this issue. While I have other judges I was in front of a judge who I remember I represented the father who was a patient, and the judge said, do you have any claims of drug use by father? And she said, yes. And the judge says, and don't tell me medical marijuana because I don't want to hear it. Don't want to hear it. So, you have judges who call some clients disgusting, then you have other judges who say, if it's medical marijuana, I don't want to hear it. I'm not interested. The law protects that person. Another question is, when a doctor's certification for marijuana contains no dosage, can a court rationally determine a particular patient is over medicating? So on the case where my client had to get drug tested, and the reason he had to get drug tested, let me tell you why. Because the judge actually ordered him, again, before I was on the case, the judge actually ordered him to turn over a copy of his medical marijuana card to his ex every single year. What the French toast? I don't know why she did that, but he didn't like it and he didn't turn it over. And guess what happened? He done pissed her off, and she filed to find him in contempt for not handing over his card. That prompted the judge to then set that person into a drug testing order. That person then hired me after they were advised to drug test for like forever in the day before they could have parenting time. So, but here's my point. The judge says, hey, when you're done drug testing, what we're going to do is we're going to look at all your drug test results. We're going to look at the level of marijuana, and we're going to talk about it. And I stood there and I said, Your Honor, as if any of us know what the levels mean. The levels are not going to tell us if father was using his marijuana at 10 p.m. at night once his kids were asleep. They're not going to say if he was using only topicals or using an edible or actually smoking. They say that none of us know that. None of us know that. So what's your point of having my client go through $1,000 of drug testing, which is only going to show weed for what? So I'm not going to go through all of these questions. The parent uses medical marijuana based on that alone. Well, who uses medical marijuana based on that alone? I mean, no, but yes, but no, but yes. It depends on the facts. If DCS comes into your life, they're coming into your life because someone's making an allegation that you're not being safe. And let me tell you, it's typically not, oh, they use medical marijuana. No, the typical allegation is they use medical marijuana to keep their bong and all the materials out. They use medical marijuana and they expose their children to the marijuana smoke. They use it's not just the use of medical marijuana, it's the other alleged dangerous behaviors that are involved. So have I ever seen a DCS case where it's responsible medical marijuana use alone? No. Every case that I have dealt with that has in terms of DCS that has a medical marijuana component, there are other issues going on in that family. Always. It is not just medical marijuana. So again, these questions cannot be answered unless any of you are dealing with these issues and want to take it to the Court of Appeals. I'm happy to help in that regard. Although I'm not an appellate attorney, to be quite frank, I would be working with an appellate attorney. I'm a litigator. I do work at the trial court level. I would be happy to work with an appellate attorney should any of these issues come up. So, like I mentioned, there are actually two cases. One case is the Gerald versus DCS. And you know what's kind of shocking about this? I'm a private attorney, right? I don't have contracts with the county. But I know a lot of attorneys who have contracts with the county that all they do is DCS work, have never even heard of this case. It kills me. But now you know of it. So if any of you are ever appointed a public defender on a and so the Gerald case is very, very friendly to medical marijuana patients. The juvenile court, where the rights were affected, they were not nice. The juvenile court just ripped this father to pieces. You spent $100 a month, wish. But in that particular case, the Court of Appeals, so for example, the Court of Appeals says, and what does $100 a month in weed mean? Unless you could show that they were diverting their marijuana funds away from food and clothes and other things for the children, who cares how much they spend on weed a month? That's basically what the Court of Appeals said. The Court of Appeals, also in my opinion, again, is to be a little bit conservative approach. I don't consume around my children. I don't expose my children to marijuana smoke. I've never been that way. Some parents are. I've been to certain people's homes where I'm like, oh, Jesus Christ, all right, I'm leaving. But in the Gerald case, and to each his own, but and here's kind of the theme of my presentation, I think, because there are so many gray areas, it's all about risk. How much risk are you all willing to take? That's really, in my opinion, what a lot of this is about. So there's some bright line rules, but there's a lot of gray area, and within that gray area, how much are you willing to risk? So for those of you who say, bullshit, I want to smoke my weed, I'm totally fine smoking weed and driving, go ahead, smoke weed and drive. Just know that if you get caught, then you're going to have to pay an attorney thousands of dollars to try to get yourself out of that. So a lot of these issues are, what are you as a parent, how do you feel in terms of risk? I have a really good friend who used to, we lived very close to each other, and we used to be able to go to each other's houses and consume, and we had the ability to have a car to pick us up because neither of us drive. Well, my friend moved. Do you think I hang out with that friend anymore and consume with that friend? No, I can't, because I'm not willing to risk driving 45 minutes to where that friend lives, smoking at her house, and then driving back 45 minutes. I don't care how much time has lapsed between when I last smoked. I'm personally not willing to take that risk, but I'm not willing to take that risk because I'm a lawyer who is licensed, that if I do have any criminal issues, my license is gone, my career is gone, my financial livelihood is gone. I'm not willing to take that risk. On the Gerald case, one of the children was tested and actually tested positive for marijuana. The Court of Appeals, and of course the juvenile court at the juvenile level, just ripped him to pieces. The Court of Appeals actually said, well, the state didn't actually provide any evidence as to how that actually harmed the child. And therefore, that was reversible as well. And some of you may agree, some of you may say, hey, but that being said, just on a side note, just make sure that mothers calling me because they accidentally one time, they always put it away, but it was that one time where they oops left that bag of gummies out, and then their 4-year-old had the gummy, just one, and generally fine. But then the dad, who's no longer with the mom, found out, and all of a sudden you're dealing with criminal issues, DCS issues, and all those other issues. So when they say and I'm going to give you some tips, best practice tips on how to be safe. So the opposite, there's another case that came out, and it's not really a detailed case. Gerald is a very detailed case, and it is 27 pages long. Good, so go from there. But there's another case called Bethany versus Moore, and it's actually not a case, it's called a slip opinion, not really an opinion, but anyway. In the family court, the judge did the same thing that not the same judge, but the judge did the same sort of thing at the trial court level. The judge ordered the father to do a few things, including, don't laugh at this because it is actually funny. Okay, you can laugh. The judge said, you need a doctor's note. And the doctor's note, I want you to bring in a doctor's note, and I want the doctor to certify you're using your medical marijuana in compliance with the law. That's an uneducated judge. No one's going to go to their doctor. That's what your certification is for. Your certification is a doctor says, you're certified to use this. By the way, it's not a prescription. It's called a certification. It's not a prescription. So and father didn't do it. Why? Because there's no doctor that was going to write a letter that says that, right? And then, lost custody rights, etc. And in Bethany versus Moore, the Court of Appeals said, you know what? I think that Superior Court judges, which are the judges you would be in front of if you're on a DCS case or a family case, this case said, you know what? I think Superior Court judges may have the ability to kind of put their own rules in place. That's kind of what this case says. It's kind of scary. But it's just not really like the case. It's not the Gerald D is not legal precedent either. There are, from what standing here today, I do not believe there's any legal precedent in Arizona for the family cases. California has them all across the board. I presented on the California issues. I'm licensed in California as well. And in regards to the California issues, it's all across the board. Depending on what county you're in, they're letting you smoke around your kids or not. So California is a different story. So here's the conservative in me comes out again, the best practices for marijuana patients that are parents in particular, possess or cultivate as little marijuana as your condition requires. That being said, I get it. I typically buy ounces at a time. Why? Because I'm not into buying, $50 vapes. I will buy generally an ounce at a time if it's a good product and there's a good sale out, and I put it in a different box. And then the rest of the weed, I actually put it in a locked safe. But that being said, just have as little as your condition requires. But I get the deals on the I get that. I totally understand. Leave your marijuana at home and go into your child's school, and don't possess them with chaperoning on a school field trip. Let me just say this.
We're not going on that trip.
Well, let me tell you this. If any of your kids are if any of your kids go to one of those wilderness programs and they tell you don't bring sugar products because the javelinas will get to them or the animals, believe them. Don't bring edibles. People, well, then I'll just bring edibles. Well, if you're in the wilderness, it's probably not smart to bring sugar edibles. Just saying.
Blast is best.
And again, these are just best practices. Again, if this is what I mean by risk. If any of you are reading this and being like, that's bullshit. No, I'm gonna take my gummies to the state fair when I chaperone. Go ahead, take your gummies. And I hope nobody finds out, and I hope you don't get caught. You know what I mean? Driving under the influence, always illegal. Don't medicate and drive. Some of you may say, I've been smoking weed for 20 years and driving. I've never gotten caught. Lucky you. Right on. But no, not safe. Not safe. And realistically, we'll talk more about the marijuana DUIs. It's a totality of the circumstances. So to be clear, for those of you who have driven after you consumed, and you don't have to raise your hand, but I'm sure some of you have been stopped for traffic violations, right? And you just have your weed the hour before, but the cop doesn't know. And the cop doesn't realize it, and the cop's not investigating you for a DUI. Why? Because you don't seem impaired. the totality of the circumstances are such that you don't seem impaired, even if you may have consumed an hour before, right? So that's really what it's all about. It's a totality of circumstances approach. Don't smoke marijuana in any public place. The safest place to consume your marijuana is at home, at your own home. I am not going to speak on the legalities or any issues when it comes to any of these public events. These parties, y'all know what I'm talking about, the industry events. I'm not going to speak on those, the legality or anything like that, because especially Dom is one of the places that has it. But let me be clear. You will not ever see me at an event where where anybody is consuming cannabis. In terms of, now don't get me wrong, I remember where I had an event where I spoke at Normal and people were smoking and I'm like, okay, and I made my presentation and I left. I didn't consume myself, but let me put it this way. I am personally not willing to take the risk of going to these medicated events. I'll just be honest though, years ago, I'd probably say that when the industry first started and started parties, I think maybe in 2015, I went to a couple of events. I did, and I learned very quickly, just for myself, I'm not going to be going to these events. But that's just me, and I'll tell you how, there's a variety of reasons, but I'll tell you one little issue. It played out in a case where at one of these events, because they're videotaped, right? The disgruntled ex used that videotape that they found on social media against the other party, who later picked up their child shortly after that event. And they were very successful in convincing a judge that parent was not safe. In part because you want to risk going to these events, I highly encourage you to do things like get a designated driver, get an Uber, or things like that. Consider medicating after your child's already asleep. Some of you are like, bullshit, I'm smoking all day. Okay, smoke all day. I'm just best practices. Keep all marijuana in a safe, child-proof location. Again, I have had a number of cases of very normal people. I mean, it was the one time I left it on the table. Yeah. Well, that one time has now caused your life to be completely a mess. Label marijuana food products, keep them far away from children's food. If your child is old enough to understand, explain to him or her that marijuana is medicine. That being said, and I think that personally speaking, I think the program outside is wonderful. I think the program to teach kids a little bit about age-appropriate information is fantastic, because we do need to speak to kids, just like we would about any medication or alcohol, for example, right? I tell my 13-year-old all the time, XYZ. But I will also tell you that some judges have actually ordered parents to not talk about marijuana. The case with the disgusting father, the allegedly disgusting father, there's actually a court order that says, do not speak to your children about medical marijuana at all, period. Don't. So there's that. And don't sell product to anyone or give to anyone who is not authorized to have it. As cool as some people may seem, sometimes they're just not that cool. And it'll come back to bite you, in the butt. Other thing, just know your employer's drug testing policy and act accordingly. I'm not going to go through all the employment issues, but I will tell you there's some actually really good positive case law for employees in Arizona through a federal court in Arizona, a federal court that definitely has favored employees as respects this issue. We don't have time to go over the employment issue because it is a very detailed issue, but some of you are gonna, want to shoot me for the next one, but get rid of your guns. The federal law, it's the Federal Gun Control Act, actually says if you're a medical marijuana patient, you cannot possess a gun. You are otherwise considered a federal prohibited possessor. That being said, again, risk, right? Risk. How many of us are gonna come across a federal officer? Probably not. Yeah.
On the federal note, a state police officer or a county deputy, most of the time does not have that kind of jurisdiction unless they work on a task force.
Correct.
You can't have city cops, you can't have county deputies, you can't have state police that are associated with a federal task force and do have federal authority.
Yep, and so your average cop, local cop, is not gonna have issues if you have a gun and you're weed in the car at the same time. Well, maybe they will, but it is actual federal crime, and unless you're really, quite frankly, Indian or out on federal land shooting your gun and you have your weed on you, you're really not going to come across a federal officer for the most part. The one about probation or parole. Now, to be clear, in Arizona, under Arizona law, Arizona case law right now, in terms of, I get this all the time as well, your landlord wants to cancel your lease because you're smoking medical marijuana. The landlord actually cannot keep you out because of the marijuana aspect of things, but they can in terms of the smoking aspect. So if in the lease it says no smoking, period, then they could actually cancel your lease based on the no smoking clause if you're actually smoking.
Leases are now stating marijuana specifically, you know that, right? They're specifically stating no marijuana, no medical marijuana.
Well, a lease that says no medical marijuana is a violation of the act, and you could, sue them, right? Yeah, you definitely can. As a matter of fact, Arizona law, in terms of the employment issue, it's the discrimination provisions. That falls under one of the discrimination provisions, and Arizona law has made it clear that if the government or private party violates the discrimination provisions, you could then sue them. So, yep. But I mean, if the lease is dumb enough to actually say, include medical marijuana, that's just stupid. That's just a stupid thing for the landlord. That being said, why give that landlord money, right? Your lease could be canceled because of just smoking, period. Moving on, so that's the gist of it in terms of family law and DCS law. Again, most of it is gray. And as I said, I encourage you to take a more conservative approach. Why? Because I see every single day families and children who are, and it's not that they're, and to be clear, I'm not saying this is true with every single case that I've dealt with, but the majority of cases I dealt with, there's something else going on. Something else going on. For the most part, there's just kind of always something else going on, and a lot of times it's a disgruntled ex, quite frankly. So, moving on, just talking really briefly about the pregnancy warning and central registry. I had some doctor's office will certify me a full 5 or 6 months pregnant. Help you. You can't force a doctor to certify you. That being said, here's the pregnancy warning, and to be clear, you kind of see this everywhere. This particular pregnancy warning actually started off as an attempt to be a law that would prohibit any pregnant woman from being able to be a medical marijuana patient. That into at least a warning. And the warning essentially says that if you guys can read it, if you use marijuana during pregnancy, there could be a risk that you'll be. But I've dealt with where there has been a central registry finding, essentially what happens if you're pregnant and the doctor or the hospital think that you are consuming any sort of substance that you're not supposed to. And that's also true of medical marijuana. Some doctors are just not comfortable with it and they will report you or they will have you tested when your baby is born. Then 201, and you do have the right to appeal because of the discrimination provision. In terms of appealing, you would be appealing to the Office of Administrative Hearings. And there is no bright line case law on that right now, especially because it's through the Office of Administrative Hearings. It's not through like the regular Superior Court downtown, no. It's the Office of Administrative Hearings, and there's no bright line rules for that either. I'm actually working on a couple of appeals for some others right now. To be clear, if the investigation reveals it's marijuana use only and medical marijuana use only, and nothing else is going on, those cases are closed. Those cases are generally closed. However, I've always, at least in my cases, I have seen that for those of you who are not familiar with the central registry finding, I call it the naughty parent list, basically. It's the state has it, and you can't get a level 1 fingerprint clearance card unless you get an exception. So for those of you who are teachers or work with children or the vulnerable, or the elder, you can lose your job if you go on central registry. Just another discrimination provision. Again, this is the discrimination provisions where if the private or government violates this, you can actually sue them. And this just says for purposes of medical care. So for those of you parents who have children that are patients, for purposes of medical care, including organ transplants, qualified patient, the medical marijuana is actually called medicine. The whole point of this slide is medical marijuana is actually considered medicine for purposes of medical care. So for those of you who are on some sort of transplant list and but they say, oh, we have marijuana in your system, it's not marijuana. According to this discrimination provision, it's medicine. So get me on that transplant list now. And then, so that's the gist of it about in terms of family. And just briefly going through the DUIs, our past law enforcement did a wonderful job of explaining stops and things like that, and I completely agree that those are the laws. Here's another discrimination provision as respects marijuana and DUIs, and that essentially, you can read it for yourself, but essentially here's the whole point of DUIs. It's a totality of circumstances approach. So if a cop smells burnt weed, oh yeah, I'd be charged. I don't care what anything else says. You smell burnt weed, it's because you just burnt weed, right? And there's a difference between burnt weed and unburnt weed. That being said, cops are also becoming very familiar with vapes and the smell of vapes and what and yes, folks, vaping is the same thing as smoking. Probably shouldn't do it while driving. So for those of you who keep your little vape pen right there in the middle console, probably put it away. Quite frankly, whenever I go to a dispensary, I purchase my marijuana, I make it obvious, I open my trunk, I put the bag in my trunk, I close my trunk, I drive away, I stop before I get to the, I stop. As biggest DUIs that I get is, you're not stopping before you exit a parking lot, and boom, there you go. And to be clear, I've also had a host of cases of stops after events. Again, that's part of the reason why. This is the stuff that I see that I'm like, okay, I'm not doing that. If you're a medical marijuana patient and you are charged, you're likely going to be charged with these 2 misdemeanor DUIs. An A1 is to the slightest degree. It's anything, any impairment to the slightest degree of anything. And then an A3 is the drug DUI. So people have prescriptions. Yes, of course. If you have prescriptions, you could actually get a drug DUI as well, unless you show the prescription. Anyway, very complicated, but basically these are the 2 most common DUIs. And essentially, when you are being tested, the blood test, because you will be blood tested for the most part, they test for carboxy-THC, THC, and hydroxy-THC. And if they find that your blood has active metabolites there's active metabolites, however, on average for medical marijuana DUIs, on average it takes about 9 months to be charged here in Arizona. That's the going rate that I'm seeing in the Maricopa County, because what do? They have to get your blood and they send it out for testing to where they have to then test for the active versus the inactive metabolites. They wait for that to come back. And if there is active metabolites in your system, you will be charged, period. And what do you have to do at that point? You essentially, to get out of the DUI, you have to get your own expert. And there are just a few experts in Arizona. So for those of you who are into other things, we need more experts. So any of you that are studying right now to be and deal with impairment, we literally have like two DUI experts in Arizona. I'm not even kidding. They're making all the money. DUI experts. So essentially, you would have to hire an expert. It is true that there is no per se limit in Arizona, but to be clear, what Arizona prosecutors do is they follow other states. So Colorado has a 5 nanogram per milliliter per se limit. So if you were in Colorado, you get pulled over for a marijuana DUI and you have 6 nanograms per milliliter in your system, you are per se impaired. It's automatic impairment. The law says you're impaired. Sorry. Nevada 2, Ohio 2. Let me just tell you, I'm not gonna deal with all of your systems, right? But for example, I had a client who had a 13. Her number was a 13. This particular client also consumed every day, multiple times a day, right? My expert was able to determine through the blood work that my client consumed every day, multiple times a day, because of the other cannabinoid count in her system. And from that preliminary report, we were able to convince the prosecutor to, unfortunately, we were not able to dismiss the case. My client was not willing to go to trial, so my client took the plea of reckless driving. So no DUI, but the plea was to reckless driving. It's traffic citation. Yeah, it's 4 or 6 points on your DMV, but my client was taking the chance of the marijuana DUI. But on that particular case, are really okay with potentially dismissing, but then said, but hold on, I want to see what the number comes back as. I want to see the number. So then they did further testing to get the actual number, and it came out to 13, and the prosecutor's like, oh, hell no, I am not gonna give you a deal. But we, like I said, that we got an expert who was able to show that the number 13, at least for that particular client, was not a high number because that client was so used to consuming. But that client, to be clear, that client also admitted to consuming marijuana just a few hours before, and that client's car also smelled like burned marijuana. So again, totality of the circumstances. Also, if any of you have this issue, there is a 2017, it's a July 2017 National Highway Safety Study, which essentially very much favors medical marijuana patients. It says your average medical marijuana patient drives a little slower, a little more cautious, and that the number, the nanogram number does not correlate to impairment. So the National Highway Safety Study, and then Jack back there was telling me that there's some more recent congressional study that follows in line with the National Highway Safety Study. They always respond with, yeah, thanks, we know about this. So just marijuana today, there's no presumptive impairment. There's no scientific consensus about how much the number in impairment is. Again, the approach is the totality of circumstances. If your car smells like weed, your eyes are bloodshot, your clothes smell like weed, you have a little bit of slurred speech, you start making admissions. The presence of pipe. Again, if a pipe is right there and the pipe is warm, hello, cops are not dumb. Cops are actually very smart. They know what they're doing. They're going to know that you just smoked out of that pipe. The same is true for vape pens. If your vape pen feels a little warm, cop may think it. So remember also that one of the ways to get out of it is through use dismiss by showing the cops that things wrong. For the most part, probably 95% of my cases, cops actually do the right. They follow the guidelines. Why? Because they don't want to mess with the case. They don't want to take the time to then ruin the case. Remember that if your child license, for example, and I had this happen. I had a gentleman who was a medical marijuana patient in part because of the seizure disorder, but because of the seizure disorder, that person has a restricted license. If you have a restricted license and you have a medical marijuana charge, it is a felony. That's another aggravating factor. If you are driving under the impaired on a restricted license. But the most important part, just as past law enforcement mentioned, is if you have your kid in the car, yeah, just don't. Just don't. And no smoking in a vehicle in public. So what does public actually mean? I'm not going to go into it, but let me just don't smoke in your car. Don't smoke in your car in the parking lot. If there is a van in there, I'm not going to talk about what vans and buses or whatever, but you cannot go onto a bus. You cannot go onto a van that's parked in a parking lot and smoke weed. I mean, you could and risk it and get freebies and hope nothing happens. But, if Phoenix PD is, staring at you and decides to stop you, they could, because you would be violating. A very new case. The case about smoking in your car is a 2019 case. I think it came out in May of this year. And it had to do with the people were in the parking lot to Mesa, in the city of Mesa. They were going to go to a concert. So they were just like in a regular public parking lot. Let's take a couple puffs. Boom. I had somebody call me the other day, a very, very responsible person called me the other day who decided they wanted to go take a puff in their car. They were at the Chase, they were at a baseball, they were at Chase Field. It was feeling achy. They wanted to go to the smoking section. Allegedly took one puff, just a real quick, long drag, one puff, then went back to the seat, and there you go. Excuse me, sir, we need to talk to you. And that person is now being charged with a felony possession of cannabis. Not of cannabis, felony possession of marijuana and paraphernalia. Why? Because he took the risk of consuming in public at a game. Now, some of you may be like, haha, I've smoked at the Chase, I've smoked at the baseball game too, and I never got caught. Awesome. Again, for those of you who have been risky enough and took risk and weren't caught, fantastic. I get it. I've been a patient for 20 years. I absolutely get it. But what you also have to get is, especially in Arizona, we're not in California where it's rec. This is a medical state. And the police are approaching it as a medical issue. Government and the state are approaching it as a medical issue, not as a recreational issue. So please understand, it's a completely different approach than if we were in California or Nevada where it's recreational. We may ultimately get to a point where things are a little more stable and safe for your average parent, but to be clear, in Arizona, they really, are not if you are not being safe. If you are being safer, you'll be fine. So those are my thoughts on family, DUI, and I think at this point, if any of you have questions for either of us?
May I bring up 2 extra points?
Oh, of course.
We spoke, both of us hit heavily on DUIs because it's such a broad spectrum. But the one thing also that you need to understand in regards to DUIs is there's the law enforcement portion of it. And when every single one of us signed for would be susceptible, or we would agree, if we're arrested on suspicion of DUI, you agree that you would do the tests that law enforcement requests. If you don't, let's say you are 100% stone cold sober and you refuse to do the tests, no matter what is in your system, your driver's license is automatically suspended for a year, no matter what, even if you're stone cold sober. But the admin per se law in the state of Arizona is through the civil side of Department of Motor Vehicles and your driver's license.
Yeah.
So, and then also I wanted to add, I've been in contact with a DCS worker who is also a friend of mine. Unfortunately, DCS did not give their blessing to be here. I'm going to put my Instagram name up on here, and she has made it very, very clear that if you have any questions specific for DCS, funnel them through me, and I can be more than, and I will send every question to her. She asked me, texted me a few minutes ago, how's it going? Because she wanted to be here. She understands that this is for the patients and it's for education. So I'll put my Instagram up in a little bit, and then you can reach me through that way.
Yeah, that reminds me. One last thing about DCS and medical marijuana patient. I've heard testimony over and over again. I do DCS cases all the time. And the testimony is this, because I asked them, what does your policy book say about medical marijuana? I don't have my policy book in front of me, but here's what it says. This is what I've been told over and over under oath by DCS workers, and that is, if you are a medical marijuana patient, you will still be evaluated for being a substance abuser. You will be medical marijuana use. You will no longer have to engage in services for substance abuse. But if they determine that there are some other substance abuse issues, then you have to go through their services for substance abuse. Quite frankly, my understanding, at least on the cases that I've dealt with, is these evaluations for medical marijuana typically turn out to include information that leads to a full program. It is rare to have a case where someone is a medical marijuana patient is evaluated and no substance abuse services are put in place. It's put in place a lot, but I'm sure people hire me when there's a problem, right? So I'm sure there are cases out there where people are evaluated and it's medical marijuana and then no services for substance abuse are offered. But on my cases, the cases I deal with, it's because people are coming to me like, they just put me through this 6-month program and I have to go to drug testing and why I'm a medical marijuana patient. Then I have to figure out things and unwind things and look at their evaluations and all that stuff. The more competent your attorney is in medical marijuana issues, the better you are off. So when you are looking for an attorney, I would definitely highly suggest to ask them about their experience and knowledge about medical marijuana laws. And if you're dealing with the DCS case or common case, do you know Gerald? The Gerald case? So for any questions for either of us, we've pretty much wrapped up the presentation. If any of you have questions about family.
I saw that arm in the back up first.
Yeah, I have a question, just because, so a few years ago, I ran into, I got pulled over. It was just for a minor traffic stop. I think I didn't my light on or something. It smelled like weed, like straight weed. But I didn't look impaired. I wasn't impaired either at the time. And there was no signs of paraphernalia, no signs of, anything. My car. So the officer, he was kind of going through the process, and he was about to start arresting me. He said he had to search my car and all this stuff. And at that point, I was like, you have to search my car. I guess I could, do it. Go ahead. I don't know. And luckily, well, for me, luckily, the sergeant actually, another patrol car, he pulled up. He was, the officer, what was going on? And he told him, I pulled over for a traffic stop. I'm checking the car. I'm going to check the car because it smells like weed. And the sergeant basically, tore the officer a new one and said that wasn't reasonable care, anything like that. He was like, no, it smells like weed. And he basically just let me go because he said that wasn't reasonable suspicion just because it just smelled like weed. There wasn't any other reason for him to say, to arrest me. But I noticed right now that was one of the things. Does it have to be just a number of things or? Totality. Since if I just smell like weed, you don't gotta do anything because it does smell like weed. I don't have anything on me, I'm
Right.
not prepared or anything, so I'm curious, any clarification?
Sure, so I'll just say right now, smell under Arizona law, and I don't remember the case year, but it was recently, within the past 2 or 3 years, is actually reasonable suspicion or probable cause for continued search. It actually is. Moreover, to be clear, just like I said, it's a totality of the circumstances. So if the officer, all he could say to a sergeant was, her car smells like weed. Bird weed? No, just like fresh weed, okay? And what else? So, totality of the circumstances. So every case is very different. Jack?
Some of what, we've seen department on trains.
That is extremely relevant information, is that there is an overriding authority in the state of Arizona called POST, which does set up standards for law enforcement needs to be trained in this, law enforcement needs to be trained in that. But it has to do with how much funding does that department have? Do they have a training department? Do they have officers that are proactive in training? And the answer to that is that there's no actual set standard between departments. Tempe PD, liberal city of Tempe, lots of college students. I called my buddy with Tempe PD. I talked to him. He's like, "Oh, we don't care. You show your card, you're driving down the road in 5 minutes, no big deal." Scottsdale PD, completely different story.
I had a client come in for an arrest on CBD cigarettes. CBD cigarettes. Possession of marijuana.
It is technically part of the cannabis plant. So therefore, if officers are uneducated, not through their own fault, but because they don't, their departments are not,
And the client's like, "What do you mean? But I put them at the smoke shop." Wow.
Yes, ma'am.
Sonia, I'm sure on Facebook a lot of people have seen that there was a case about smell not being probable cause. And we all share it through our groups and stuff, but you're actually saying that it is probable cause in Arizona.
That was an Arizona case?
No, I just know that we've all
There-
seen them too.
I've seen a lot of links to other states,
Right.
and there are many other states that say smell is not, but in Arizona it is.
It is.
It is.
I think she's talking about, at one point, the groups that were shared was that if you have your med card, through the process that you say of things I was smoking on property, on private property, in my own car, it's not my car smells like that, my car, my dispensary agent. What crime is committing here, friend? That would make sense of probable cause not being applicable, but if you don't have your med card, car smells like weed, you're kind of SOL.
Every case and the case facts are so unique and so different. And in terms of the training, you said the training that the officers have, they have different training. So for example, through my recent criminal cases, I am learning that Maricopa County officers are being trained like this in terms of concentrates. If you have anything more than 2.5 grams of concentrates on you, and you're stopped by Maricopa County officer, that officer may believe you're not in compliance and may charge you. Why? Because some of you may know that Maricopa County, because of the Jones case, has been doing their own extractions for purposes of expert testimony. So they can have experts go on and apparently Maricopa County, with all due respect, they have not used the best extractors, if you will. They can't extract anything out of the plant to where the average extraction is for every 2.5 ounces, they're getting approximately 2.5 grams of concentrates. We all know that 2.5 ounces is the limit for possession. And so that means that 2.5 grams of concentrate. So it is very possible that a Maricopa County officer, because they're being trained this way, they're being trained to 2.5 to 2.5. Just got to be careful. You just got to be careful. I'm not saying don't go to Encanto and don't get the 8 for $99 special. I mean, some of you may just not want to go there anyway. But I'm not saying that. But I'm saying if you do, put it in your trunk.
Yeah.
Be safe.
Obviously, what it sounds like is what the officer is trained on. We just have to know what that officer knows and help that officer.
And all of the information that's been disseminated today is for the compliant patient, I would say for the most part. Like again, there's activity, but this is for the 100% compliant patient.
Somebody on Instagram Live was asking, what about if your vehicle doesn't have necessarily like a trunk that's separated, like you have a
Yeah.
Is there any,
I would suggest if you don't have an actual trunk, I would suggest some sort of box, a lock box where you put it in. where it's locked, and then it doesn't emit the smell. Like I said, I buy ounces at a time, so yeah, if I have that in the backseat of my car, it's gonna smell. So I don't put it in the trunk.
And it's one of the
So, like
things
boxes.
too, in regards to risk. I drive a pickup truck. I don't have a trunk. So therefore, if I'm coming from the dispensary, I put my stuff in the back and I stick it underneath the rear back seat. So, just as far as I can, so it's out of the way.
Perfect.
And so like the glove box, if the glove box is locked, is that okay?
Again,
Well, here's the problem with the glove box. Yeah, the problem with the glove box is you open it to, and your weed falls out. And
For me, like with my
But that's-
glove box, I actually, like the key is on my key, so I can't actually
nice.
turn my car off and, like unlock it, like they would.
That's what I mean. At least that's what I mean about risk. It's all about risk. Understand what the law says, understand there are gray areas, and then you take the risk in terms of what behaviors you're willing to engage in.
and the thing is too, is that there's no law that says you can't have it sitting